So in Virginia, a seller cannot unilaterally void a residential sales contract once it has been ratified. That means that both parties have signed and accepted all the terms on the contract. Real estate contracts are legally binding agreements, and once you sign it, both the buyer and the seller are obligated to perform according to the terms. That is, unless a valid contingency or contractual right to terminate exists. So number one would be if the buyer breaches the contract. If the buyer fails to meet the deadlines, like delivering the earnest money deposit in time or securing financing on time, the seller may have grounds to cancel and potentially even keep the earnest money deposit. But there's also contingency clauses that are in the seller's favor. Some contracts are going to include things like that. That would be like a home sale contingency or suitable housing clause. It's really called a seller's home of choice. If these are in place and they're not met, then the seller may cancel. There could be a mutual agreement to terminate where both parties could agree in writing to void the contract with a release of liability. So what a seller cannot do, they can't just change their mind and say, hey, we decided we don't want to sell our house anymore. And they can't back out because they got a better offer. They can't refuse to close without legal grounds. These can have consequences. It's called improper termination, and the buyer can sue that seller for specific performance, and they can also sue for damages or losses that they incurred if the seller says, hey, we're not selling our house anymore. So if you're a seller and you're thinking about backing out, or you're wondering what are your rights, it's wise to consult your real estate attorney or your agent to evaluate the contract terms, to figure out what the laws are and how you can best move forward with a situation like that.